4939 Chestnut Street.
This is Marshall Williams.
Hello, Marshall.
Yes, this is Marshall.
Marshall, can you come up, or are you just going to be on the phone?
I can speak with you on the phone. I don't know how or if I can, with this phone, access a video.
Okay. All right. Are you going to be you're not sure you're going to be testifying in this case?
Am I going to be testifying?
Yes.
I guess so. I had reached out to a couple of lawyers
Okay.
to get some assistance with it, because there are two other matters related to this property that might be important, and
Okay.
I'd ask for a little bit more time.
Marsh, hold on. Yeah, Marsh, hold on. I'm just trying to swear you in and things like that. We're going to get into your testimony. Is your lawyers with you?
No, I am awaiting a decision from two of them, two lawyers that I've spoken to about this matter.
Okay, so you're going to represent yourself here today, all right? So what I have to do, Marshall, I have to swear you in, okay?
Yes.
So could you please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth?
I have my right hand risen, and I swear to tell the truth and the whole truth, nothing but the truth, I guess.
Okay, good. Tom, raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth. Yeah, Tom Robakowski.
Yes.
Okay.
I'm sorry?
No, I'm just swearing other people in. We'll get right to you, Marshall. I'm Wayne Miller. I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted Agus, board member.
I'm Matthew Wojcik, LNI supervisor.
Hello, Auto Boards Administration.
Okay, Hillary.
Sorry, Hillary Emerson, board counsel.
Okay. Bill, could you read that into the record?
Yes, sir. There's two items for the same property. First being MI 2022-006-718 for the property 4939 Chestnut, and MI 2023-00640 for the property 4939 Chestnut Street.
Okay. Tom, you want to start us out?
Yes. So
We're talking about a different property.
Who's that?
This is Mark Fink. I think.
Hey, Mark, how you doing?
Good. How are you?
Are you
These are open hearings, so
4939?
we'll get to you.
I'm sorry, sir.
Mr. Fink, what property are you here for?
141 to 143 North 4th Street and
Okay.
325 Cherry.
Okay, so we'll be with you in just one moment on that.
Okay.
Right now, they're doing a matter right before.
Okay.
To explain to you, we have to bring everybody into the room. This is a
Gotcha.
public hearing, okay? So we bring everybody in and then we go down the line, all right?
Yes, sir.
Okay. Tom, could you go ahead?
So you have, on today's docket, you have matters 1 and 2, all concerning the property at 4939 Chestnut Street. There are 2 cases that are written against this property, both declaring the property as unsafe. The first one has to do with the front porch. The second matter, which is number 2 on the docket, has to do with other structural issues with the property. The first stance that the department's going to take on the first matter is that this should be dismissed, in that this has already been adjudicated. There has already been a ruling by this board back in December 15th of 2022. This board made a ruling that the applicant had 60 days from that date to obtain a make-safe permit. That matter should be dismissed as it's already been ruled upon. I'll share my screen and show the ruling on that matter.
Okay, no, good.
Tom, how did this get in front of us again? Was it a new appeal made?
So there was an appeal to the second matter, which is the interior structural issues, and I believe the appellant just filed the appeal on both of them, as they are two outstanding violations on the property. But with that said, this is the ruling from the board back in December of 2022, in which there are all three signatures, and the applicant has 60 days to make that application. In the other matter, which is number 2 on the list.
Tom, I got a question. Tom, hold on. Is
Yeah.
that matter taken care of? That is done. They complied?
No, absolutely
Okay.
not.
Okay, go ahead.
I'm sorry, I had a difficult hearing what question was asked.
I asked, was the violation on the first violation taken care of that we met in December of 22 and gave you 60 days? And I asked Tom if that was complied with it, and he said no. So we're going on to the next one right now. Go ahead, Tom.
So we have the other matter.
Let me ask a question about the matter just, I guess, addressed. What was the question and the question and the answer to the question? I'm sorry?
Tom
Hello?
Told us that the first case for this address, the case was dismissed. Okay, hold on, Marsh. I then asked, was it complied with? And Tom said no. So this is dismissed. We're moving on to the next one.
Okay, was I supposed to appear at the hearing or respond to the request? Because I'm relatively sure that I would have had I've been informed about it.
Mr. Marshall, in 2022, there was a hearing. You were given 60 days to make the corrections. And it sounds like it didn't happen. We already ruled on this, so we're not going to rule on it again. That's all we're saying.
Well, was it a hearing on it, or it was just was there a hearing that I was invited to participate in it, or was it just a decision made by I'm assuming the board?
There was a hearing that you would have been invited to. I don't know if you were there, but the ruling was that you were given 60 days. That should have been mailed to you. And that was in December of 22.
Yep.
I don't seem to have anything in my paperwork that shows that, but
listen to the case that we are actually going to listen to today.
Yeah.
And we can sort out the other stuff later, but just let us proceed, and then you can respond to that. Okay?
All right. Thank you. Yes, thank you.
What time?
So we have another appeal that was filed for the property being declared as unsafe. And that matter is in front of the board. I am sharing my screen. I'm going to cut right to the photos that show the interior of the property. These were photos that were taken of the exterior. These were back in 2022.
Is there a specific date for the on which the photos are taken?
In fact, the first set of photos that the board is looking at is November 28th of 2022. These were presented to the board at the last hearing for the conditions of the front porch. And then the next series of photographs is going to be the conditions of the interior for the case number CF 2023-003632. See that there is a significant amount of material in the one photograph on the right-hand side. On the left-hand side of the presentation, there is significant interior issues with the structural members of the property. These are another set of photographs that were taken of the interior. Essentially, what the department is asking is for a permit to be in the system within 30 days.
Excuse me 1 second. Mr. Williams, are you able to see the photos?
No, I don't have any visual.
You don't have any visuals. You can't see what's being shown
No.
at all. Okay.
What do we do now?
I mean,
Hello?
if he can't see what's being shown, he can't respond to it. We may want to continue this so that he can be able to access it, be able to have video access next time.
Yes, I'll make certain that I can get to some place or phone that I can have access to the visual, or I cannot be present in person, can I?
We're not doing in person. We haven't done that for a little bit. Yeah. So you have
Okay.
to have something to visual, to come in like a Zoom meeting.
Tom, are you comfortable with basically pushing this off for 2 weeks and
Yeah.
making arrangements for video to do
Okay.
that?
That's fine.
Okay. All right, so this case will be continued for 2 weeks at the next hearing. And you'll have some type of a visual thing that you can see what we're presenting, and we can see you, Marshall. All right?
Last question is, am I permitted to have access to that prior to the next hearing so that, or is it, just at that time that I would be able to view it? Hello?
What's the policy? Or can we give him something, or I don't
So
know
the
how we would get it
photographs
to him.
are generally part of the L&I case record. I mean, Mr. Williams knows the state of his property. If he contests that, then he should bring his own evidence.
Okay. You hear that, Mr. Williams?
I say, I can hear you better, Mr. Chairman, than I could hear the witness or whoever
Okay.
presented. What did he say? I'm sorry.
What he
I
said
can or
is
cannot have.
all right, that's property of L&I, okay? You know what condition your property's in. When you come back, when you can see the photos, you will, we'll go from there, and you can contest whatever you want to do. Because you know what the property is. You can't have the photos.
And you can provide your own photos.
Your own photos.
That if you feel they show that the property is in good shape.
All right, I understand now.
Okay. We'll see
okay.
you in 2 weeks.
All right, thank you, sir, and both members of the board.
Talk to you.
All right,
Okay.
bye.
Okay. Okay, next case.
Mr. Miller,
Yes?
these are the matters for Cherry Street and 4th Street. There are 4 cases. Would you like me to read all 4 MIs into the record?
Sure.
MI 2024-004-706 for the property located at 321 to 323 Cherry Street. MI 2024-004-707 for the property located at 325 through 327 Cherry Street. MI 2024-001-660 for the property located at 141 through 143 North 4th Street. And lastly, MI 2024-001-661 for the property located at 141 through 143 North 4th Street.
Okay, we're gonna start out with the 141 to 143 North 4th Street. The code that ends in 001660. That's the one we're doing next. All right. So that'll be with Michael Phillips. Are you here, Mike?
I am here. Good afternoon, board chair.
How you doing?
Good,
Mike,
how are you?
Are you a lawyer?
Yes.
Okay, so we don't have to swear you in. Is there anybody else with you that'll be testifying in today's matter?
Potentially, yes. We have Tom McInerney,
Tom
Scott,
McInerney?
Scott. I don't see him
Bauer.
anymore.
Scott Bauer. I'm
Oh,
here.
I didn't see. Sorry, I didn't see Scott. Scott Bauer and James Puglia.
Okay. All right, so what I have to do, I have to swear them in. Okay, how about Tom? You there, Tom?
I am.
I am.
Okay, no, not you, Tom, yellow Tom. While I have you there, I'll swear you in. Tom, raise your right hand. Swear to tell the truth, nothing but the truth.
Yes.
Okay, Tom McInerney. Tom, are you there?
Yes.
Okay, Tom, could you please raise your right hand? Swear to tell, are you a lawyer? Is that any of these guys lawyers?
No,
If you're, okay, you swear to tell the truth, nothing but the truth.
I do. Yes.
Okay, Tom. How about Scott? Scott?
I'm here.
Okay, could you please raise your right hand? Swear to tell the truth, nothing but the truth?
I do.
Okay, and Jake, where you at?
You mean James Puleo?
Oh, I thought it was Jake. I'm sorry. James,
That's okay,
how you
I've been
doing?
told.
Okay, could you please raise your right hand? Swear to tell the truth, nothing but the truth?
I do.
Okay, we'll get started. I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted August, board member.
Matthew Wojcik, I supervisor.
Philip Motto, boards administration.
Hillary Emerson, board counsel.
Okay, Phil, could you read that into the record, please?
Yes, sir. This is MI 2024-001-660 for the property at 141 through 143 North 4th Street.
Okay, Tom, you want to start with the with this case?
Did we read the matters for Cherry Street into the record, or are we doing them all separately?
I read all four into the record, Tom.
Okay, so first, a matter of housekeeping, for matter number 6. So that would be MI 2024-001-661. That matter has actually been closed. That is marked complied in our system, so
Okay.
that does not need to go in front of the board.
Okay, good. Go ahead, Tom, continue.
The other matter, which is the items 3, 4, and 5, they all
Okay.
pertain to a shared party wall or a shared wall. And in fact, there is a issued permit for the repair of this for this defect. That make safe permit is CP Charlie Paul 2024-002220. And that permit is still issued and still open. With that permit in place, there's really no ruling by the board because the permit will satisfy the violation in its entirety. The question becomes, and is looking at some of the documents that were presented via email yesterday and to the board, this seems to be a case where it's basically access to one's property to make the repair. That's really not something the board has jurisdiction over. So with that, with a permit being issued, the matter is moot. If the permit becomes expired, then the department would seek a line of enforcement. But as long as that permit is open, we would like work to start within 60 days and address it as that being. With that, the department will rest.
Okay, Hillary, what we have to do anything else?
I suggest that we hear from the parties just to clarify what the issue is, and then we can move on.
Okay, let's hear from the parties. Let's do it.
Thank you. I'll be brief. Inspector Rabakowski summarized the situation pretty well. I'll just note on behalf of 141 to 43 North 4th Street, we secured the make safe permit. We have been attempting, even preceding these violations, to remedy this issue and to demolish the single-story party wall, the other side of the party wall, which is the Cherry Street property, is mostly a surface parking lot. However, it still straddles the property lines and is a party wall. We've satisfied our duties and obligations in securing the permit, but we have not been able to do the work, even though this is a shared obligation and it's a shared duty. We cannot do it if the neighbor continues to refuse to allow us on their property to do the work, and that's the situation we've been in. We have been seeking access since securing the Make Safe permit repeatedly, to no avail. The owners of the Cherry Street properties have refused to allow us on their property. We sent a temporary easement, very boilerplate, straightforward. It was refused. I finally today received a draft back, and it has all of these provisions in there that would essentially cause my client to pay additional monies and a ransom, pretty much, just to do the work that needs to be done to remedy this issue. So we are ready to proceed with the work. I would just note, in response to Inspector Rybakowski's mentioning that they'd like to see the work done in 60 days, or they might continue with fines. We wanted to see the work done more than 60 days ago, and so to the extent that there's any fines or any penalties that would accrue, we would. It's our position that should solely be on the Cherry Street properties, as they are the ones who have not taken any steps whatsoever to remedy the defect, and instead have just stood in the way of this condition being made safe.
Can I ask?
I have Mr. Bauer here who can testify. He inspected this wall even before the city did, and has consistently said it's unsafe. Mr. McInerney is on behalf of the owner, and Mr. Pulio is here if there's any questions regarding the means and methods set forth in the building permit application to remedy the issue.
If they can't get into the place, what happens then, Tom?
Since it is a shared wall, the department would seek action against both owners and then spell the Court of Common Pleas to issue an order or seek fines against the owners.
Can I ask what the proposed repairs are?
So I have a copy of that permit. I can share it with the board. Let's see here. That's a copy of the permit that's on file that's still issued for 141 North 4th Street.
May it please the board, my name is Andrew Miller. I'm the attorney for the neighboring property. We have a pending appeal before you. And when you're ready, I'll be happy to provide you with my client's perspective.
Wait, Tom, do you have pictures of this wall?
Because I can see what the process is.
Give me 1 minute. I'll dig through the file and share it with the board.
Thank you.
And to the extent it would help, Board Member Rivera, I do have the demolition plan that was approved along with the Make Safe permit, and that was sent to the board yesterday as well. And perhaps if that was shared, that does show the wall and does show the plan for the bracing and the demolition.
Okay, I'm just trying to understand the impact on the neighboring property.
Yes.
Absolutely.
I'll be happy to speak to that.
Okay, let's see it too. I want to see it. Let me take a minute to pull it up, and then Mr. Miller, you can talk.
Mr. Phillips, do you need assistance sharing your screen?
Oh, I can share my screen. No, I thought Mr. Rybakowski was going to be sharing his. So
I'm downloading it right now. Give me 2 seconds.
okay.
Okay, where's it at?
It was a little quick 2 seconds there, Mr. Miller. You gotta remember, we're using the city network here.
Yeah, I know. I hope I live this long, Tom. Gee. Okay. All right. All right, Tom, we see the pictures.
Okay. So you essentially have the wall is right here where the cursor is. And that's the area. The aerial view is here. Let's see if I can enlarge it. Can everybody see it?
Yes.
So this essentially is the rear view of 141. That's the aerial shot, and then that's the interior rear view of the demolition area.
And where's Cherry Street up? That brick building?
Cherry Street is here. So to come in, you have to be on this side of the property to make to do the work.
And just to be clear, are the owners of 141, pardon me, intending to do that work or proposing to do that work, including the cost of doing that work? Is that something that you're taking on, or is that in dispute as well as to the responsibility for the repairs?
Notwithstanding the fact that we believe it's a shared 50-50 responsibility under the law, for purposes of the proposals that we have made since securing the permit, we have agreed that we will do all of the work and incur the cost to do the work because we believe it's imperative that this work be done and be done quickly.
Thank you.
Okay. Mr. Miller, you want to tell us why you don't want to give them access to that area?
Good afternoon, Mr. Chairman. May it please the board. My name is Andrew Miller, and I represent Think Realty Partnership LP, the owner of the adjacent historic property. The board should know that my client has for 30 years owned the property and operated the property next door, which consists of 13 apartments, 9 offices and commercial uses, a health spa, a skincare spa, and 15 parking spaces. My client has been the custodian of these historic properties for the last 30 years. My client has been an integral member of the community, and the choice of words that Mr. Phillips used when he said ransom is really rich, because ransoms are demanded by those who hold hostages. And if anyone has held a hostage in this circumstance, it's been Mr. Phillips' client, the owner of the property next door. First, I want you all to know that the issue of this wall has already been the subject of several days of hearing before Judge Roberts in the Philadelphia County Court of Common Pleas. Mr. Phillips filed an action for an injunction to compel my client to provide access so that Mr. Phillips' client could repair the wall. That wall belongs to Mr. Phillips' client. The evidence at the hearing was, and I'm happy to take the board through that evidence, but I don't think it's an efficient use of your time. That evidence showed that the wall is entirely on the other side.
It's absolutely not true.
Okay.
I mean, I don't like interrupting, but I mean, that's just plainly not true. And I can have a survey that I can pull up to show it's not. So
I have a plan as well.
and the city has gone out and staked it, but go on. I don't want to
Okay.
interrupt it.
Judge Roberts denied the motion for injunctive relief, which sought to compel my client to turn over the entire parking lot, that for the way that Mr. Phillips' client proposes to perform this work is to take over my client's entire parking lot, to deny my client's tenants access to parking, which is essential in Old City. It's very, very hard to park. To deny access to 4 of the apartment units in the building. To dismantle the hardscaping, the flower surrounds the entire area, and to disrupt the neighborhood more than has already been done during the last 2 years. Mr. Phillips' client got a street closure permit for Oriana Street. Mr. Phillips' client has been torturing the entire neighborhood by denying access to the homes on Oriana Street so that they can park their trucks in the street. The neighboring property owner has rained bricks and debris on my client's property, on my client's tenants' cars, on the neighbors. And the city councilman, Councilman Squilla, has been involved. It's a disaster area. And so for Mr. Phillips to suggest that my client's requirements for the ordinary protections and for strict deadlines for performance of that work and for alternative parking for my client's tenants and for alternative housing for my client's tenants who will be denied access to their apartments during an estimated 2-week construction period is not at all unreasonable. And the fact that Mr. Phillips could not obtain that relief in court speaks volumes.
I will just say that relief was sought before the unsafe designation. We were proactive in this regard. This was before LNI had deemed the wall unsafe. And there was no substantive ruling. It was Judge Roberts just felt that there was no emergency or urgency that would compel us to go on the property immediately. That was over a year ago. And the circumstances have changed. We have this unsafe designation now, and I don't believe it's relevant. The only issue here is there's an unsafe designation. The city views it as a party wall. The city views it as a shared responsibility. One of those 2 parties is willing to perform that work and abate the violation, and the other is not willing to allow that work to happen.
Judge Roberts' reasons for the decision are not in the order that Judge Roberts issued. I don't think Mr. Phillips or I can give the board an explanation of Judge Roberts' thought process. What I can say is that precisely the access that and by the way, if I can share my screen, I think I have a few photographs that that might shed some light on this.
Okay, go ahead.
Thank you. This is sorry,
Do you need assistance, sir? You
I'm
hit
just
share
sorry.
and then pick the screen you want.
I have the photo up. I'm sorry, I don't know.
So did you hit the share button at the bottom? It's green, has an arrow pointing up.
I apologize. Let me see if I can.
So
Here we go.
while he's working on that,
Yes.
the Make Safe permit, was that the drawing from AR Engineering? Or was that the letter from O'Donnell Nacarado? Because AR Engineering just shows the bracing that you put up. And while that may make it safe, that's not a long-term.
That's during the demolition. So that's proposed to ensure safety during demolition.
Can the wall not be demolished from the the 4th Street side?
To the greatest extent possible, we would limit that, but to safely do so, we need to have some buffer on the other side, because, you know, just.
I agree there should be some protection. But I would think if those presses were supported, you could demolish it from 4th Street.
Yes, the majority of the work, as much as possible, would be done on our side.
May I see the photo that was displayed a moment ago by Mr. Robakowski? I think it was a photo appended to this exhibit. Right. Okay.
I can enlarge it if you need me to.
Yeah, go ahead.
I just, what I wanted to see was whether it's this. Yeah, it's. Okay. Well, the rear view of 141 North 4th Street, to the left is the area of my client's parking lot. Now, what I'd like to do, if I can somehow share my screen here, and I'm sorry.
Now, Andy, I hate to interrupt, but I saw your screen for a few minutes and your beautiful family, and then it disappeared.
I'm sorry for that.
Okay, just saying you had gotten something up.
Yeah. All right.
There you go.
How about now? Are you able to see this?
Yeah.
Yeah.
Yeah,
Yep.
yeah.
There it is.
All right. I want you to understand the scale of the project next door. Now, the wall to the left, which is the you see there's a CMU block, and then it transitions into the original brick. That's the area. That's the area that has to be removed. And you can see the extent of the excavation that occurred on the other side. So to suggest that the only way to remove that wall is to do it from my client's side, I question that. You can see just the scope of the work that occurred. But my client has endured, and I could show you the photos of the trucks parked on the sidewalk. I can show you people dumping excess concrete on my client's driveway. And I can show you all sorts of other roof debris being shoveled onto my client's property. My client is living under siege, and my client is doing everything it can to provide for its tenants and to be a good citizen in Old City. And Mr. Phillips' client cannot say the same thing. And if we were to have a full hearing on this matter, as we did in the Court of Common Pleas, we would have all the residents of Oriana Street to share their horror stories over the last 2 years. And I believe we're now on the second or third general contractor on this project.
You're on the second, and all of that's irrelevant. And all of this is a smokescreen just to deflect from the fact that there's an unsafe condition, a violation issued by LNI. We are seeking to remedy that violation. Despite the fact that it is a shared obligation, we have, for purposes of the Make Safe permit, been willing to take on the cost, the expense, and the work of doing it. We've agreed that we will limit any impact on the neighboring property. But this has been something that the date of the make safe permit is over 6 months ago. We've gone nearly over half a year of trying to do this work. And if there was, a genuine concern, there would be an effort to work collectively to see that the unsafe condition was remedied.
We are not saying that the work cannot occur. What we are saying is that accommodations must be made to limit the harm to my client's business, to my client's property, and to the lives of my client's tenants. So all of this is to say, I'm not sure what else we can do today, but I cannot allow the board to end this hearing without understanding that my clients are reasonable people with reasonable concerns, and those concerns are not being accommodated.
And
From what I'm hearing, they are trying to preserve and keep safe your client. Tom, what are your recommendations on this?
Mr. Miller, Andy, Mr. Miller,
Okay.
do you have a picture that shows our property, our side of the wall?
I don't know. Tom would have that. Tom, do you have a picture of their side of the wall?
Excuse me, who was speaking? I don't believe it's someone
Oh,
who's
yeah.
been identified or sworn in.
I'm speaking, Alexander Fink.
Okay, I don't believe Mr.
Alexander,
Miller.
hold on.
Yeah, Mr.
Alexander,
Miller's clients were not sworn in. Thank you.
Are you a lawyer, Alexander?
No,
Okay, just raise your right hand, swear to tell the truth, nothing but the truth.
I do.
Go ahead. Speak.
I was asking if Ellen I or Mr. Miller, my attorney, had a picture currently, or I could find one hopefully quickly, that shows our side of the property wall. Because every picture that was presented on that LNI application, except for the picture that was aerial, only shows the client's construction site. And I think it's important to see the historic character of our property, and also that it's not just a backside of a wall. It's a corridor that services 13 apartments, 9 professional businesses, and one of the routes that this corridor leads to is directly adjacent to this wall and services 4 apartments, 2 of which I have octogenarians living in who would be greatly affected by all this. So I would like for the board to be able to see from our side of the property, the perspective. The other thing I wanted to mention is that we have an issue that was demonstrated in front of the court with the contractors basically approaching us with good faith, having incompetent contractors and having inconsistent timelines. So when this project was started,
We have new contractors that are here right now, new GC that's been in place for a year. They are extremely reputable. Mr. Pulio can speak to who they are. They've built major projects throughout the country.
Excuse me, Mr. Phillips,
And
if you
I think
mind,
this
I'd
is
like to
all
finish-
irrelevant.
Excuse
Go
me,
ahead.
Mr. Chair, can I just interject to clarify where we are procedurally? From what I understand, LNI's position on this is in terms of the 4th Street cases are that they've essentially been complied. One, because, well, one's already been closed and one's essentially complied because a make safe permit has already been issued. I am not clear what the status is on the Cherry Street cases for LNI. So I think it might be helpful to hear from Mr. Rowankowski, and then we can allow Mr. Miller and his clients to respond, because I think the board may need to make a decision on those cases, whereas it seems that the 2 4th Street appeals are moot at this time.
So the 2 4th Street, to clarify Ms. Emerson's statements, one of the 4th Street's cases that's on the docket for today is complied. The other one is this shared wall, and it is the department's issuing of the unsafe case. The 2 matters on Cherry Street are this wall. and the one on 4th Street encompasses this wall. So it is the department's belief that this is a shared wall and that it's a matter between both parties that this needs to be resolved. In resolving it, there was a permit that was issued. That's basically where the department is. The department is saying, hey, there's a permit issued. It's now a civil matter between property owner and property owner. It has no jurisdiction with the board because there's a permit. The permit speaks for itself. Permit says, hey, make the repairs. If not, the permit will be expired. If it gets expired, then the department has the opportunity to seek some other line of enforcement by way of the Court of Common Pleas. But that's not in front of this board. Right now, what's in front of the board is the violation, and is the violation accurate? Violation is accurate in that there is a unsafe case, and that unsafe case is being rectified by a permit. That work needs to start and be conducted and be completed. That's it from the department's standpoint.
And the thing is that Hillary, it's muted, so it doesn't mean anything to us unless they got 60 days to start the work, and if they can't start the work, and then L and I would come back in and I guess start the procedure of going to Common Pleas Court. But as for us, we're finished.
All right, and Mr. Rabakowski, can I just one second, Mr. Fink? Sure. Mr. Rabakowski, just to clarify, the department it's department's position that both owners are the owners of the 3 properties are responsible for the wall. I understand that, but with the permit, was that issued in such a way that it covers all 3 of those properties, all 3 of those violations?
It covers the repair work, yes.
Okay, all right. I just wanted to clarify that. Thank you.
Mr. Miller, board chairman, if you don't mind, I would like to briefly finish my testimony before I was interrupted. And I actually have these pictures as well that I'm arranging so I can quickly share.
Fine, go ahead.
All right, I'm going to try to share my screen here. Okay. And I apologize for any frustrations that I may.
Problem.
Okay, I sent a request, it said.
Tom, can you take your
Andrew
screen
Miller
down?
has to stop sharing.
Oh, okay, sure.
You should be able to share now, Mr. Fink.
Okay. Thank you. Open system prep settings says I have to give it some type of permission. I'm sorry. Bear with me one sec. Just got to let Zoom access my computer. Password. Okay. Zoom would like to be able to record the contents if you're screen. You can choose to quit now. Later. All right. Let me see if it works now. Sorry. Okay, perfect. So here I have the picture. If you're standing in the parking lot and you're looking into our property and you're looking at the wall in question on your right with white paint. So as you can see, it's a corridor that leads directly to the building that says 137, 139. So our attorney has been working to protect the people that live there, 2 of which are octogenarians, make sure that they have a place to safely live while this wall is being demolished. And before I was interrupted by Mr. Phillips, I was saying that we have the neighboring developers have not demonstrated any good faith to us or competency in fulfilling what they say. So I was first introduced to this developer, not by a letter of introduction, not by a, hey, we're planning a multi-million-dollar development next to your property. I came to my property and I found construction trucks and metal material all over my parking lot. And when I approached and asked what was going on, I was told to basically, go F myself by a bunch of construction guys. So then for the preceding weeks, they continue to trespass on our property, destroy our property, and adversely affect the life and health of all of my tenants, in which case we were forced to retain a lawyer before they brought us to court to simply get them to stop wreaking havoc on our property. Now, if you see this corridor here, you can also see just a little bit of wood. Is there a way I can quickly change the picture? I have other ones ready to show.
Go ahead.
No, I'm not exactly sure how though.
Oh, you're asking the wrong guy.
I think stop share and then just start again. Hold on one second. Yeah, here we go. So if you see here, you're going to see basically the same exact space taken from those residents who are octogenarians, front door to their apartment, essentially. They walk into that apartment. That's the only access they have to the staircase that leads to their apartment. If you see in front of you is a wooden enclosure, that's where the trash and recycling is for all of the residents and businesses at my complex. So again, my attorney has been working with them, or we've been looking from them a realistic plan to demolish this wall, rebuild it while looking out for my residents, the existing infrastructure on my property. When they turn it into a construction zone, not only are those 4 apartments who can't even get home going to be able to get home, no one's going to be able to take their trash or recycling outside. And I'm not going to be complying with my Philadelphia refuge exemption that I need to have that on site at all times. They just present us a 1-page thing that says, you know, we're going to take over this part of your property, draw a line, say some timeline that makes no sense. They told us that we would have those 4 tenants in a hotel for 1 day. And even the court questioned them and asked if they've ever done a development in Philadelphia before, because it is impossible for them to knock that wall down, make it safe for my tenants to return in a 24-hour period. And they do not demonstrate to us or any of the neighbors, as Mr. Miller brought up, any sense of good faith. So I could call to this board probably a dozen neighbors who live immediately within this area, and they will testify that this project was supposed to be completed in spring of, I don't know, 2023 or 2023, I think, spring of 2023. The deadlines just keep getting pushed back further along. And I firmly feel that if they are allowed to form a construction site on our property, we are going to be held hostage, because I'm not going to be able to remove the men, the equipment, and everyone who lives there and works there and relies on it as a place of business is going to be in trouble. And they all look to me and my father basically for security in where they live and where they work. And if you look at this picture that I'm sharing on the right side, you'll see the back of a German colonial schoolhouse that has been there since the 1750s and was a place of business for Benjamin Rush, Benjamin Franklin, many of the signers of the Declaration of Independence. And currently it is used as a luxury health and skin spa. I don't know how many people are going to get a massage or a facial when you have rogue developers who are based in Texas, who are now on their 3rd contractor, their 2nd site superintendent, because they have these outside contractors. The owner of the property is not here, has never been present. They have Tom, who works for them, but the ownership is based in Texas. Their model is buy properties that are messed up, put as many units as humanly possible in, and then sell them. They have no interest in this neighborhood. They have no interest in my tenants or their life or their businesses. And I don't really know what else to say. It's upsetting, honestly, as you can see. And, you know, I feel like I am the steward and the guardian of the people who I shook their hands. Me and my father do an old school type of real estate. So when I meet a tenant, I meet them at the property. I explain to them what it's going to be like to live or work on my property. I present them a lease and I stick with them through the whole process. And I'm extremely concerned. And I cannot let them on my property because they show me a 1-page packet that says we're taking over this piece of your property for 6 weeks and you'll have your tenants back in there overnight.
I apologize. I understand your frustration and the frustration of the whole group here with what's going on. But right now we can't do anything. As long when that permit got pulled, we have they met the requirements that we expected because it was unsafe. But we don't get involved in the, you know, the party wall, you know, about access and things like that. That would have, and I don't believe, Tom, correct me if I'm wrong. Does the city don't have a party wall policy, do they?
No.
Okay, so the thing is, now you're gonna have to, I guess it'll probably have to go to court for that. But if we had a policy about, you know, shared walls, then we would have some power, but we don't. It ends with us as soon as we get the permit. And, we can't do anything to make you do something or make the other person do something. It's right now, it's gonna be 60 days. If there's not a work being done, then it'll go to common police court, and then it's out of our hands. So we don't have any control over that. And the thing is, you know, my thing is that we've seen a number of these all for years that we've done this. And the thing is, it's frustrating, and I you know, we're for all parties involved. And the thing is that until they get a party wall policy, this is going to keep happening. It's frustrating for us because we can't do anything.
No, I understand your frustration. I understand the position you're in. I know that Mr. Miller, my attorney, was trying to show you guys and was being interrupted and said that all these circumstances are irrelevant. And I honestly think it was deceptive on the LNI permit from the beginning, only to portray a derelict construction property that's being mismanaged and say, oh my God, look at the danger here. When on the other side, we have birds chirping and a beautiful place for people to live and work. And I wanted the court to see that. Or the board.
First of all, we're not a court, and
Of course.
just wanna make, you know, we're a board, and the reality is there's nothing that we can do to basically, you know, clarify or give direction in this circumstance. You guys have been, this is your, it's good practice for, it appears you're gonna end up in court and having a discussion about this. Our concern in the meantime is the wall that's there, Tom, Robakowski. It's, obviously, you're looking for kind of a, you know, permanent resolution of what happens with that wall. In the meantime, is it safe? And I'm also concerned about the, you know, the people on the Fink side of the wall, you know, in the meantime, or if it's not, is there a way that both parties can agree to something that at least stabilizes it, makes it, you know, safe in the interim? And maybe that's all that we're talking about here, but it sounds like, you know, we're looking for a much more elaborate resolution. And you know, so I guess Tom, is your feeling that as it is right now, are people on you know, on the side of the wall that are living on the side of the wall, are they in danger? And how do we deal with this while this presumably goes through months of, you know, court process?
And I hate to interrupt, but before I finish, I think the only important thing to add is that, as Mr. Miller, my attorney, mentioned, my father's owned this property for over 30 years. We have maintained the status quo of the courtyard, and the wall's never been a problem. But as you saw, the extent of the demolition and the excavation that occurred on site is why you now have a potentially unsafe wall.
We hear you, and we're not able to, you know, make a determination.
I understand.
About who's at fault with this. Right now, our concern is, you know, we just want to ensure public safety in the meantime while all this gets resolved.
I understand.
That's all that I would. So give Tom a chance to kind of weigh in.
Thank you for your time.
Tom, are you there? We just see your name.
Robakowski.
I am. So I'm sorry, I did not hear the question.
Sorry. Okay. Very simply, is the wall as it stands right now, is it unsafe as it stands, or is it unsafe because of the activities that are happening on the other side of the wall? Our concern is, the concern is this is going to take a long time to resolve, not by us in court proceedings. What do we do to ensure safety of the people in the meantime on the side that, you know, the Cherry Street side of the wall?
Ultimately, what would happen is if this permit became abandoned, or became expired. And throughout that, the department would keep an eye on the unsafe condition. Engineering reports were provided to the department in that the wall had a structural defect and that it was declared as unsafe. And that's where we're at. The permit was pulled for the repair of the wall. We would continue to under the obligations of taking a look at it and inspecting the property. If it changed in any way, then we would take the appropriate action.
Could they make repairs from the construction side of that building, that wall, I should say? And right now, I think that would probably, I don't know, I'm just saying.
So that would not be up to for us to determine. That would be up to the design professional to determine.
All right.
Amy, that was your question before, right?
Yeah. I also do want to know, I mean, we filed our appeal seeking time to perform the work under the Make Safe permit. I still have not heard what any basis is of the Cherry Street appeal, and we're the ones that have obtained the permit. So I don't know, the basis for their appeal can't either. It's that the wall is not unsafe, in which case they'd have to come and show us some support for that, or otherwise I'm not sure who's being afforded 60 days and why they're being afforded any time to continue with their appeal rather than their appeal simply being denied.
Tom Rybakowski, do you have a recommendation to the board of a time allotment for the Cherry Street properties to do what they need to do to correct this violation?
Tom gave us that. He said 60 days.
Can I maybe add something to that? Because we're talking about professional opinions and things. We've had multiple structural engineers look at this, one of whom is on the call today. So it's not as if we want this situation to occur. It's not fun for us to have to be here to do this. It is what it is, and we're looking to address it safely. So the other side hasn't produced any professional opinion or anything. So I understand the inconvenience, and we try to be mindful of that. That's why we have a new GC who is extremely professional and has several hundred units in Philadelphia under construction right now, and is effectively a regional semi-national brand. But we have structural engineers who said it's not safe. We're not trying to do this for fun. They haven't had any professional provide any opinion. So if we could do it from our side, we would. It's not my choice that we do this. I want to get it done as soon as possible and just not have to encounter this anymore.
Just to follow up on Tom's point, in court in front of Justice Roberts, I believe, their structural engineer testified that it could be done from their side in court.
It was before further deterioration and over a year and a half ago.
I mean, we have a structural engineer here. It's like in a construction professional, it's physically impossible to not at least the primary use of your side is to have a safety buffer. It's not like
I'm just saying what your professional testified in court.
Okay, if I like Mr. Phillips were to provide my understanding of the reasons for the judge's decision, I think Mr. McInerney's credibility would have been one of the biggest problems that the judge had. But I'm not going to do that because I don't know what the judge was thinking. But what I will say is we appealed this violation because we said the wall is not a party wall. We said it belongs to our neighbor. We also said that to the extent there is damage to that wall, it's a result of our neighbor's activity in the massive construction that's going on next door. So that is the basis of our defense. And but I understand that it's moot by the issuance of the permit. So that's where we are, and I'm grateful that the board has taken the time to understand this. This is the source of tremendous frustration for my clients. It's the source of tremendous frustration by the neighbors on our Oriana Street who are living under siege.
One thing I want to put out, also, I'm just nervous with winter coming. I would prefer if this were taken care of before the weather got worse. So,
Tom,
you
when
guys-
was the permit issued?
Permit was issued. Permit was issued April 22nd of 2024.
And if you don't mind, when was the first construction permit issued on this site?
See how that's
don't know
relevant.
that. I don't have that in front of me.
But, okay, so at that time, they were given 60 days then, right?
No, so under the terms of a make safe permit, work is to start within 30 days or that permit can be expired. In meeting, in scheduling the initial inspection, that's when we were abreast of the access difficulties that the contractor or that they were having. So we've continued the permit to be open. And we understand that there's a repair that needs to happen out
Right.
here at this
The
location.
thing is that if we're at loggerheads and nothing happens, then we're 60 days, then they'll have to go to court. Can we just say, look, the permit's been issued 6 months ago. So in my opinion, they couldn't get it resolved in 6 months. Can't you resolve that permit to say, hey, it's done, go to court?
I mean, yeah, we can, because no work started, the department can expire this permit as no work is started today.
The thing is, there comes another thing to me, to this board. We already said, get the permit. And I vowed, being the chairman here, I don't want any type of building to fall down. I see you have the elevator shaft up. I see that everything else is there. If that wall falls down or somebody gets hurt, then it comes back to us. Okay, so I think we gave ample time to have them try to work it out. They can't work it out. Someone has to work this out. Okay, and that, to me, it would have to be the courts. Or if they could work it out themselves, but I don't think that's going to happen. So it has to go to court. It just can't sit like this forever because we gave the permit and nothing's being done with the permit.
Mr. Miller, if I may just say, we secured this permit April 22nd. I emailed Mr. Miller immediately after that. I have reached out to Mr. Miller constantly. I sent a few emails about, let's talk. We need to get something. Here's an access agreement. I've received no substantive response whatsoever until before this hearing. So it just smacks of being disingenuous to come here and say, well, they haven't gotten it done. They've had plenty of time. We have been diligently trying to do this work. We understand that it is an unsafe condition that needs to be remediated, and we are willing to take the cost on, the responsibility to do it all with minimal impact and disruption to the neighbor. And the answer has consistently been crickets or no, not unless you do it in 14 days and give us $5,000 a day for every day thereafter. I guess, yes, it would have to go to the courts, but that's not by virtue of anything we have done limited. Let's just look at the universe of this issue of this make safe permit. What more can we do here? So I appreciate and respect it. If the permit were canceled, we could just file another one, exact same permit, showing our continued commitment and willingness to do this work.
There's something has to give or something has to move, and we don't have the authority to make that.
Can I just add in, the Cherry Street addresses have an unsafe wall facing their property, potentially causing more damage if it goes, because the way that truss is on it would probably go into your property. I think it really behooves you to work this out and let this wall be removed and rebuilt. There's ways to protect it so that your occupants can still have a safe path out. I think it behooves you to get this done.
Yeah. And obviously there's some, reasonable accommodations that are going to have to be made, financially or in terms of just, relocation of people temporarily. However that works out, we urge you to work it out together. unfortunately, we can't step in and do anything about this. And it'll be a shame if this sort of sits around for another couple of months into the winter and you still end up in court and it still has to be resolved, months from now. So we urge you to do what you can do.
And the last thing anybody wants is that wall to resolve this matter itself.
Yeah.
Yes. So, I know it's difficult for both sides, so you gotta try to work it out, because if it was me, I shouldn't get mad. The thing is, I wouldn't want to go to court. I don't want amateurs telling professionals like you two guys what you're doing. You gotta work it out somehow and make it equitable, for each side. So, but it just seems the longer it goes on, the more people get their feet dug in the sand, and nothing's going to happen. And again, I shouldn't even be saying that, because it's not, but again, I hope you can work it out. Tom, if you feel that 60 days from now is fine, we'll go with it.
Honestly, I think we're fine with less timeline. We've wanted this to be resolved for a very long time. I don't think they're going to agree to anything in 60 days. So I frankly want the issue done. Like, I'm confident in, we just want the wall to come down. I'm not trying to win anything. We've offered a bunch of, Ted mentioned, compensation. We've offered to park people places. We've offered a number of different things because there's been so many different versions we've sent. So if we shorten the timeline, I'm fine with it, because I just want this thing resolved. If we didn't have to go on their property, I wouldn't ask. I swear to you. Like, I'm not trying to create this issue.
All right, I think we need to move on.
What's that, Abe?
I think we need to move on.
Yes.
We've given our decision.
Yeah. You got 60 days, guys, and I hope you work it out.
Mr. Chair, just to be clear, the board really isn't making a decision in these cases. It's really up to L&I as to how they handle the permits, because there's a permit already been issued, and normally this board's decision would be to make safe permit, and that's already been done.
You're right. You're exactly right. But whatever it takes, Tommy, he handles that, so it's fine. All right. Okay, I hope it gets worked out, guys. Sorry for that we can't do it. We just don't have that authority.
Thank you.
All right, thank you.
All right, guys. Good luck, everybody.
Thank you very much.
All right.
These questions, somebody ask Passyunk. Is Passyunk next?
Let me take a look here.
Yes,
Passyunk's next. You got it. Okay?
Perfect.
All right, is everybody ready?
Yes.
Okay. All right. Who's going to be testifying for Passyunk?
Catherine Haley.
Okay. Are you a lawyer?
I'm a lawyer, and David Denenberger is a lawyer.
Oh, you're both lawyers. Is there anybody that isn't a lawyer going to be testifying here?
Yes, Catherine, maybe, but Catherine Haley.
Okay, Catherine, let me see your face. Where you at, Catherine?
Put your microphone on, Kitty.
Catherine.
I'm here. I'm here.
Okay.
Hello,
Catherine,
sorry.
if you're going to be testifying, okay, how you doing, Catherine? Is that with a C or a K?
Catherine with a K, and they've written my name wrong on the screen. It's Haley Roth, ROTH.
Okay, thank you. Thank you. Could you please raise your right hand, swear to tell the truth, nothing but the truth?
Yes.
Okay, we're going to get started. My name's Wayne Miller. I'm the board member.
Nice to meet you.
Nice to meet you.
Amy Rivera, board member.
Ted Agus, board member.
I'm Matthew Wojcik, L&I supervisor.
Philip Motto, boards administration.
Hillary Emerson, board counsel.
Okay, Phil, could you read that into the record?
Yes, sir. This is MI 2024-005 451 for the property located at 736 through 738 East Passyunk Avenue. David Denenberg Esquire is the appellant. He's present in the room, sir.
Okay, Tom, do you want to start us off here?
I think I haven't been sworn in, though.
Oh, you have, oh, sorry. Tom, please raise your right hands for the tell truth, nothing but the truth.
Yeah.
Okay, Tom, start us off, let's go.
So this involves a shared wall between the two properties on Passyunk, which is 736 East Passyunk and 740 East Passyunk. It is the board or the appeal that was filed is saying that the wall is not the responsibility of 736. It is the department's belief that this is a shared wall. And then we do have documentation that was provided to the department that a survey was conducted and it is in fact a shared wall. And we have belief that the owner is trying to engage the services of an engineer and make the repairs to the wall as it's required. With that said, I would ask that the board take the recommendation of 90 days to get a permit.
So,
Okay,
if I may,
yes,
since you say it's a shared wall and we think it's not, has 740, property owner 740 been cited?
Yeah.
Okay, yes. I'm sorry, did you say yes?
I didn't.
The property owner of 740 does have an unsafe designation on their wall.
Tom, when you say the property owner is trying to get a permit, you mean 740?
No. The email that I received back in August from the appellant is I am trying my hardest to comply with the city's requirements. I paid for a site survey with the city surveyor's office, and they tell me it is complete, but they haven't provided it to me yet.
Yeah.
As soon as I get it, I will forward it to your office, hire an engineer, and get the work performed that is needed. I do not want any more time to go by without communicating. My neighbor at 740 who filed the complaint is still being quite difficult and refuses to understand that this is more than just a stucco issue in her courtyard. I will keep her abreast of the city survey and more to the engineer as quickly as possible. And then it goes.
Yeah, if I may, you did say that 740 was cited, correct?
740 does have a unsafe designation on the property.
Up
it here.
I'm sorry, your garb, I didn't, your voice kind of fades out. So that is yes?
I'm gonna confirm that right now for you, sir.
Because we only had this sticker. We were the only ones.
Catherine, you can speak.
Yeah, you
Okay.
can.
I want you all to know that I did get a city survey. I did hire an engineer who used the survey from the city and made recommendations and did a plan. I did hire the contractor and gave him the city survey and the engineer's report. They told me that they would initiate work within the month and that it would be complete within about 4 to 6 weeks because of their scheduling. It has nothing to do with me anymore. It's about my schedule, their scheduling. My problem is that my neighbor has been difficult, will not speak with me. And so I've just gone ahead and arranged everything and paid for everything. And I guess I'll have to deal with her after the fact, but I didn't want the wall to be unsafe any longer. And that's where I am right at this moment.
740, to clarify the record, 740 East Passyunk, which is the neighboring property, does have an unsafe designation for a leaning shared wall with 738 East Passyunk.
Okay.
But no permit has been pulled to date for applied for
either property, correct?
Okay.
But, and is access to the other property necessary to do the repairs that this can all be done independent of that. Okay.
Yes, my property was a 3-story factory. The top 2 floors were removed. The party wall was left up so that it would maintain the integrity of her property. So my property is actually very small. I have a garage, which was the first floor, that has been turned into a home. And the area that we're talking about is on that remaining wall above the 17 feet of my garage that goes up 2 more floors. Does that make sense?
Can we share the picture so the panel understands where the problem is?
I can't do that. Because I don't.
I can.
Pardon me.
I'll do it now.
This is the court reporter. The gentleman on the right, is that Mr. Denenberg?
Yes.
Thank you.
Mr. Robakowski.
Okay.
So the problem is up in this area, these bricks. You can see the 40 is this one, which has the facade that goes all the way across, which they now say is the party wall. And these bricks, it's there's some loose bricks up at the top that are accessible through the street. So we think a boom can access that, a crane, from the street, because this is the front of the building. 740 is on the left and 736 is on the right, our clients. But I think that the recommendation was to give us 90 days to get a permit, and I think that would be acceptable, and then we could see if we can work out with the neighbor. If not, we'll take care of it and then deal with the neighbor in a civil in court, I guess.
That's the what the appellant is showing, and I'm sorry, I know Mr. Denenberg. I'm sorry, this is the first time I had the privilege of having the other party.
It's Mr. Bruno, Tom Bruno. Tom.
How you doing, Tom?
Good.
So these are pretty much the exact same photos that the department has as well. And the department representatives, including myself, have been out at the location and have spoken to Ms. Kitty out at that location as well. So we don't have any problem with the 90 days.
So 11:30 or 7:38, we pull the permit and start the work? Is that what we're saying?
Yes.
If they can do the work from 7:38, not affect 7:40, and then however they recoup the cost, that's a civil matter, but we would like to have the problem rectified, or at least a permit issued with work started within 90 days.
Now, we're saying that 7:38 has to pull a permit, 7:40 has to pull a permit too?
Well, 740 hasn't filed an appeal to this jurisdiction, so they know they have the violation. We've actually spoken to both neighbors out at that time we met on location.
Okay, and Ms. Roth, she's willing to get a permit and do the work?
Yep.
Yes, Judge. Yes.
Okay, okay, if that's what's gonna be done, and then Tom, what are you saying, 90 days?
Yeah.
Okay. I'm fine with that if Amy and Ted are.
Yes.
I'm fine.
Okay. All right. Okay.
Thank you all.
Good luck.
appreciate
Anything
your help.
else? Okay, you're welcome. Good luck, everybody.
Thank you.
Thank you.
Bye-bye.
Thank you, panel.
All right. Okay. Take care of that one.
Yeah, can we get them involved in the last case?
I wish. I wish. That last case is a difficult one, man. You went 7 stories next to your building, it's like, wow. Okay.
They actually
Bouvier Street.
They actually picked up and moved one of those buildings on 3rd Street and relocated one of those historic buildings because the historic commission wouldn't allow them to demo the building.
Wow. Huh.
I thought, wait,
On Third Street or on Fourth Street?
It's on Third. It's right, I'm sorry, it might be on Fourth. It's right where the church that used to hold the live nativity.
Yeah, that's on
Yeah.
Fourth Street. Yeah,
They
that's.
tore that all down, and then there was a historic building just to the right, so just south of Race. They
yeah,
picked it up and moved it 3 parcels over.
Wow. Go take a look.
wow, yeah, I'll look by that when I go by. So, are we ready for, Bovier Street?
Yes.
Okay, bring them in.
Oh. Sorry.
Okay, who's here from Bovier Street?
Can't hear you.
I can't hear anybody.
I sent them a prompt to unmute.
Dawn Bellamy, property
Miss
owner.
Bellamy, how you doing?
Hello. Sorry,
Good.
I had to talk to you in my car. About to pick up the kids. Sorry.
That's okay, I got you, no problem.
Okay,
You're gonna be
okay.
testifying in this case. Could you please raise your right hand, keep your other hand on the steering wheel? Say, swear to tell the truth, the whole truth, nothing but the truth.
Yes,
I'm
I
sorry,
do. Thank you.
Miss Bellamy, we need you to pull over and be stationary
I am
while we're
pulled
doing
over.
this
I'm
hearing.
pulled over
Okay,
already.
yeah,
I'm
you
pulled
can't be
over.
driving while we're having the hearing.
I know.
Thank you.
Okay. All right, is there anybody else testifying, Miss Bellamy?
No, I'm speaking for myself.
Okay, I'm Wayne Miller, board member.
Amy Rivera,
Hi.
board member.
Ted Ogden.
Hello.
I'm Matthew Wojcik,
Hello.
LNI supervisor.
Philip Motto,
Okay.
Boards Administration.
Hillary Emerson, board counsel.
Okay, Phil, could you read that into the record?
MI 2024-001-207 for the property located at 2322 North Bouvier Street. Dawn Bellamy is the appellant. She's present in the room today, sir.
Okay, Tom, where you at?
There.
All right, raise your right hand, swear to tell the truth, the whole truth, nothing but the truth.
Yes.
Okay, do you want to start the case off?
So we have the property at 2322 North Bouvier Street has been declared as unsafe. This case is actually a very old case. It dates back to, forgive me, I want to get the date right. The violation on the property actually goes back to April of 2019. So with that said, it's really a untimely filing, and that notices have been sent out throughout the going from 2019 all the way through to 2024. This matter was continued from last hearing, and then it was scheduled for today as we wanted to ensure on what was going on with the property, and I'm going to share my screen. The property is that there is a tree that is in the adjoining property at 2320. There's a vacant lot, and that'll be more illustrated by the photographs that I will share in a moment. So this is the appeal that was filed in March of 2024. But the violation, as I said, goes back to 2019. In the interest of time, I'll go right to the case file and show you the photograph. This is the lot next to the property. The property is on the right-hand side. Problem is there's this large tree that has taken root next to the party wall and has actually impacted the party wall between the vacant lot and the property at 2320 North Bouvier. The department has actually issued a violation to the owner of 2320. That violation is recent. It has not, I don't believe that owner of 2320 has gotten that notification as of yet. But they too have the right to appeal that violation. But we, the department is seeking that, a permit for the repair would be pulled in, 90 days.
What?
But these are the photographs. This is August of 2024. This is the property, that's under appeal for today, of 2322 Bouvier Street.
How is 2322 North Bouvier Street supposed to correct it when it's on the neighboring property? The issue is on the neighboring property.
Thank you. Thank you.
Well, I don't have an answer. That is a civil matter. Unfortunately, like I said, the notice has gone out to the owner of 2320. And it appears that this tree has taken root in the vacant lot and has impacted the adjoining property. So, and hence, but it is a foundation wall between the two properties, so it does need to be resolved.
Do you have photos of the damage it caused to the party wall?
Ms.
I
Bellamy
do,
was
but I
kind-
can't access it.
Okay.
Tom, I was asking a question that I didn't realize I was on mute, so forgive me. Is the reality is, it doesn't make sense to do the repairs, or certainly to complete the repairs until the tree has been dealt with.
Right.
You guys, in the same way that, you know, if people don't comply, demolition order can be given for a building. Can a demolition order also be issued for a tree, or, you know, where it encroaches on a neighboring property?
So unfortunately, City Council passed or removed the tree violations from the property maintenance code that L&I enforced. So those tree violations are no longer part of the enforcement that L&I has.
Okay.
What we are up against is if that tree impacts somebody's property, we issue the notice to that owner, whatever property has incurred the damage, that they have an issue going on and that they need to repair it. How they recoup those costs and how they resolve that matter between property owner and property owner, the department doesn't they don't get involved in cause and effect. It's basically just repair what's going on out there at that location.
Tom, if my neighbor has a tree and it's growing onto my house,
Right. Thank you, sir.
I don't have the ability to have them take that, to get that down?
You have the ability to cut everything that is in your airspace, but you would have to go to civil court and explain the damages that you received and that they would, and what they would be responsible for in the repair of that property. To force them to cut the tree or maintain their tree, that would be up to a judge to order them to do so.
And while they're allowed to, you know, take care of anything that overhangs the property, you can't take care of the root structure.
Correct.
Can I speak?
Sure, yeah,
Sure, go ahead.
Okay, starting all the way back from 19, I let them do all the talking because I wanted to hear what they had to say. So starting from 19, I was the one that initiated the report. The reason that I did was because I noticed that this problem was getting out of control, and I kept having to have my roof trimmed because the roots of this tree keep digging into my roof. So I'm getting my roof repaired more than every 10 years, more than even every 5 years. So it was a bit much. So I tried to acquire the lot, and they froze the sheriff's sale that day. And then that next week, someone got, for some kind of investor, had the option to bid out before me, and I was the neighbor right there at the location. So then I contact him and I tell him, sell me the lot. All the repairs I've been making is a vacant lot. This is a nuisance area, and I've been securing this lot for 20 years. So he hiked the price up to an astronomical number, and we didn't make the deal. So then I waited for some time. I went to Daryl Clark's office and I explained to him that I'm a low income person. I was just trying to secure the lot because so many times shootings and they're putting drugs over in there. I have small grandchildren that I'm raising. So to secure the perimeters of my house, I gated this place up, bricked the ground, did all of this stuff at my own expense, knowing that the lot wasn't even mine. So even now today, if they want to drive past there, they'll see that people are throwing trash in the yard, doing all kinds. Once he obtained the lot, I stopped doing because that's not fair. That's not fair to me as the resident of the community. Not only that, they're still throwing trash in there. I get all the fines for that because, like Ellen and I said when they came, I have the existing house, so I get the fine, which I did not understand.
I don't understand it either, but go ahead.
So then I go to Daryl Clark's office and I complain to Daryl Clark. He says, call the tree man. I call the tree man. He comes out to do an estimate. It's $15,000 to take up this tree, plus the infrastructure of my wall, which is lifting up from the bottom like you pull a sheet back. So then I sent a certificate. He says, you got to contact them to show, got to contact the owner of this property to show that you're taking the initiative to contact him yourself. Well, I've sent several letters and since 19, even till this year, to say, we got to do something. We got to do something. He never responds. I left messages just like the picture he just pulled up. One day they just popped a sign in the ground, said, oh, this is for sale. So I called the number at the bottom to say, hey, you guys need to get in touch with me. I'm the neighbor. We have a problem. Nobody responds. So now we're back and I'm getting all of this mail. I don't even live in this house because of the damage. Like, because it's keep going through the roof. I can't keep paying. Right now, I don't even have a job. I'm currently in Johnstown because my daughter needs help. So I'm raising her children. I just took custody of the children. And this is where I'm at right now. I have no money to put in this house right now. But at the same time, it's not fair for them to keep coming after me when I'm making all the necessary repairs. But who has $15,000 laying around that I could fix a problem and then go later on to get reimbursed for the mishap it's caused? So what do I do in a situation like this when every time I'm asking for help, they're saying, oh, it's nothing we can do? I don't know what to do here. And the people that's right here with me, if it is a civil matter, how do I get them to engage in their part?
Tom, how does she get them to engage? Tom. Tom.
Yes, sir.
Do these, you know, I just have to say, does she have to put up with this all the time? It's, and I'm gonna say it ain't fair. You know.
So this case was, this matter was before this board 2 weeks ago at the last hearing date. It was continued.
You didn't show up.
No, I was here.
Nope. Nobody, my Zoom, nobody called the Zoom. I didn't understand how to work that. I never received a letter. I live in Johnstown. That's what I'm trying to tell you.
Oh, no. Hold on. If I remember correctly, there was a connection error.
Oh,
It kept fading out.
Yeah, but Gene Starworth contacted me and said, oh, I don't know what happened. We just need it. Now he's trying to get me to come right now before Friday to meet, to give him the key to go inside my property. For what?
Ms. Bellamy, if you give me 2 seconds, I'll be able to explain everything to the board where we're at.
Okay.
So this violation has been active since 2019, but you filed your appeal. In doing research for your appeal, I noticed that the tree and what the inspector referenced back in that original case made reference that the tree had impacted the foundation wall of your property.
Yes.
That said, the tree is not on the property. It is on the lot at 2320. So rightfully so, the department needs to issue a case to the property owner of 2320 and you 2322, because it is a shared foundation wall, a shared wall that needs to be repaired. That violation and I asked for your hearing that was scheduled 2 weeks ago to be scheduled for today so that we could explain to the board what was going on. I
Okay.
also asked Inspector Stallworth to contact you because we wanted to verify if there was damage to the party wall and the foundation wall all the way through your property.
Okay.
Because if the damage was all the way through your property, then the correct assumption can be made that both parties are responsible. That violation, because Inspector Stallworth tried to reach out to you, and in your conversation with him, you did make reference that it did impact your wall, and it has come through. That being said, a violation, a notice was sent out to the owner of 2320.
Okay.
So
All right.
that's where we're at.
All right. So as far as Mr. Stallworth is concerned, I contacted him I came to Philadelphia Thursday. It cost $75 each way to go and come from Johnstown to Philadelphia. Is a 6-hour ride. So it's 1-day trip. So I contacted him on Thursday, and I contacted him Thursday to let him know I will be in town on Friday. So maybe we can arrange between Friday and Monday for him to see the property, because I still have to get back. I have small children like that. So he said he was on a demolition site. He cut me off. We didn't get to talk. He never called back. Monday, I called him all day. I did not know that the city was closed because they have school out here. So I did not know that the city was closed. And he informed me on Wednesday when he called me back, which was yesterday, to tell me that I have until Friday to get in so he can get into the house to look around. When I said it was structural damage, you can look from the outside to see that it's lifting the side of the house up. There's no damage on the inside, but he can look, but I can't come when he wants me to come. It doesn't work like that. And I feel like so much pressure that he's putting me under because he needs access to property, which I understand, but there's nobody there to give the key to. I'm in Johnstown.
I get it, and I understand that. So let's move on from right now. October 17th of 2024, we'll move on from that. We have the department has just issued notice to the adjoining property.
Thank you, because nobody was issuing anything to him.
Well, that problem should be rectified because that owner is going to get notification of something going on out there on Bouvier Street.
So
thank you.
That said, let's call it. I don't do this often. I'm going to take the position. I usually only give 90 days for a permit recommendation to the board. I'm going to go against my normal what I normally do when I represent to the board. I'm going to represent that we give 120 days.
All right.
For you to, and 120 days stay of enforcement. It's not ordering you to get a permit. It's 120 days stay of enforcement, basically meaning that gives 120 days for the other owner and you to come up with a plan.
Reach an agreement.
Reach an agreement and come up with a plan on repairing the wall. And that would have to be done under the terms of a permit. But it's 120 days.
Tom, question in the meantime. The neighbors notification that they've just been sent out, when they receive that, how long do they have to appeal if they choose to appeal to us as opposed to dealing with it? Like when would we be seeing them?
So the violation would go out the door. Technically, they have 5 days to file the appeal, but we all know that the appeals get filed late. If I notice that an appeal is filed, I will ask for it to go in front of this board at a very expedited.
And so my follow-up question to that is, would is it normal, would Ms. Bellamy be able to attend, virtually, not you wouldn't have to be in person.
Thank you.
But to attend that, or is that not appropriate?
No. So here's the thing. This is a public hearing.
Okay.
So if it's a public hearing, those notifications are public. If they do file an appeal, I will contact Ms. Bellamy myself and give her the date.
Okay.
Thank you. Thank you. Because I don't have no idea what to do. I'm just sick and frustrated of all all of this. And when I had the money to fix it and just get this right, they wasn't on
In the-
board. So now
in the
I'm
meantime-
struggling.
In the meantime, Ms. Bellamy,
Yes.
give you legal advice. Okay? I can't give it to you. What I can tell you is I would seriously consider consulting with Community Legal Services on what to do with this property.
Okay.
Okay?
Okay. Yes.
All right.
Thank you. I appreciate you.
Can I
Thank
ask
you.
when the violation on 2320 was issued?
Actually, that violation notice in that case was issued today.
Oh, wow.
I noticed her violation in 2019 was imminently dangerous and it noted the tree, but yet 2320 didn't receive a violation until today.
Because, you know, he said
There's
I'm sorry, the guy that came out, the inspector that came out said it has to be on a standing house. So we were arguing out there because I didn't understand that. Clearly, you can see the majority of the tree is just spreading out. So that's how it's getting to my side because it's not being addressed as an old tree, you know, like an old tree. It's just not being addressed.
It's so we I understand. And so my representation to the board today is 120 days day of enforcement, a permit or something to be within 120 days.
I got it.
And if
I
an appeal
appreciate
is
you
filed,
guys helping me.
I will reach out to you, Ms. Bell.
Yes. Thank you so much. Thank you so much. I'm
Good
stressed
luck,
out.
Ms. Bellamy.
Yeah.
Thank you. Thank
All
you.
right.
Thank you. Bye-bye.
Don't forget to pick up the kids if you haven't done that.
I know, right? I'm still standing here. All right, bye-bye. My nerves are shot.
Yeah,
So,
okay. So 120 days. I'll tell you, you know, there's two things that come up today and it comes up often. The thing is that the shared wall with the two people we had earlier. Testifying in the case. Oh, excuse me. Who's gonna be testifying in the case?
Ashley Phillips.
Ashley?
From Stantec.
Okay. Who else?
Tong Nguyen. I'm also with Stantec. I am principal in charge.
Okay, what's your name?
Tong Nguyen. It's spelled Tuong. Last name is spelled Huynh.
Okay. Who else is gonna be testifying?
We also have our client, Josh Kiesler. He was on. He might have took a nature break because we were waiting for a little bit.
Yeah, you get a certain age, you gotta do them things. Okay, anybody else?
Nope, that's just the three of us.
Okay, here's the deal. I gotta swear you guys in, okay? If you're a lawyer, I don't. If you're not a lawyer, I have to swear you in. You're on mute.
Yeah, no, we're not attorneys.
Okay, all right. Tom, can you raise your right hand, swear to tell the truth, nothing but the truth?
I do.
Okay, let's, is Ashley there?
Yes.
Okay, Ashley, could you raise your right hand, swear to tell the truth, nothing but the truth?
Yes, I do.
Okay, is Josh there?
Did we lost Josh? I think he might have stepped away for.
Okay,
No, he's there. He's there.
So he's here.
Okay.
He's here.
We just can't hear anything.
Tony,
Are you on mute, Josh?
Mute.
Hey, Josh?
Are you on mute, Josh? Josh, you on mute? My other is not working. I will call in. Okay. Yeah, so Josh, so Tong and I are the architect for the project. Josh is the owner of the condo within the building.
Okay.
So he's owner's representation.
Yeah, if he's gonna testify, I gotta swear him in.
Sure.
Okay. Hey, Josh, you hear
Does
me?
the visual work with him raising his right hand and nodding? Does that work as a swear?
It ultimately it needs to be on the record. So I don't know if it's possible. Josh can maybe call the number and then use the audio from the phone call.
Yes. Sometimes it's the headphones as well. If you're using wireless headphones, that has an effect on Zoom.
Okay. Hey, Josh, can you hear me? All right, Josh, when you can hear us, come back in, all right? And if you're gonna talk, I just have to swear you in, all right? I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted Agnews, board member.
John Matthew Wojcik, LNI supervisor, sorry.
John Dimes, Fire Code.
Ryan McSherry, board counsel.
Philip Motter, boards administration.
Okay. Phil, could you read that into the record?
Yes, sir. This is MI 2024-006-256 for the property located at 3624 Market Street, 4A and 4B. Ashley Phillips is the appellant. He's present in the room, sir.
Okay, whoever's going to present the case, please do.
Good, Ash.
Go ahead, Ash.
All right. Okay, can you see my screen?
Yes, we can.
So, so I'm part of InHealth, who representing today on their behalf as their architect. They're currently an owner, partial owner of the 3rd floor of this building and the 4th floor of this building, which is condoed. So it's a multi-tenant condo 5-story building. They currently own now and occupy. What they do is basically they train foreign doctors from outside of the country coming in to practice in the city of Philadelphia. So basically they review them, and Josh can probably speak more about, but basically it's like a teaching or administrative board review of their work. So within there's mock medical areas, a bunch of offices, and some training rooms. Initially they wanted to have these training rooms, seminar rooms, which individually are, less than 750 square feet, all 4. And by the code, any room less than 750 square feet or less than 50 occupants is a B use, obviously an A function. Now, with that being said, a couple times a year, they would like to have a larger training room with 1 or 2 presenters at the front of the room. And basically having modern photo operable partitions here in the room. But when you open up this room, these 4 individual rooms into one larger room, it becomes an A use by right and by code and a function. And by doing so, and also the fact that, go back a little more, this building is partially sprinklered. It's not a fully sprinklered building. And by changing the use, it requires the building to be fully sprinklered, which we are not. So that, and then the fact that we are a condo and we do not have access to other, areas of the building, that's our hardship, is to, fully sprinkler the building. And also, per chapter 7 is the requirement of separation of mixed occupancies. So the 5th floor, we would need to provide a 2-hour barrier, because right now, by looking at the current construction type of the building, which is 2A, it only has a 1-hour floor assembly. Now, I cannot confirm or deny what the rating of the actual assembly is in place, but looking at a 2A, it's only a 1 hour. Now, the code states a B to an A non-sprinkler building, we're required a 2-hour floor separation. Inherently, it may have that, but I cannot confirm that. So that also along with that, the code states that, supporting structure. So I need to provide that separation between 4 and 5, and all structure supporting that needs to be, brought up to that. So support columns of the building, based upon the construction type, are only a 1 hour rating required of that construction. Like said, I can't confirm if that's current existing construction would meet that criteria. So being as it's a condo building, that's why we're looking at our hardship, if these were individual rooms with not operable walls, this would be considered a B use, not requiring a sprinkler or any additional upgrades. But because we are, changing this to operable walls, and now this becomes an A use and a function, it then, requires the additional fire suppression.
Other than the fire suppression, are there any other requirements of the larger space that are not already in place? Obviously, you have multiple doors in that instance. I mean,
Yeah, we have 3 exits, 1, 2, 3. We're increasing the occupancy, but we're also increasing the toilet load count. And I've also included on our code summary up here, plumbing calc. So required fixtures 4, 9, 5, 10, 4. So we're above and beyond what's required by code for plumbing fixtures. So we meet the criteria on all other areas of the code. Travel distances, we don't have any dead end corridors, so we meet all the criteria. It's just that the use requiring the sprinkling.
Yeah, and your client has the 4th and 5th floors, or the
they own a portion of 4. So the full floor 4. They basically own this portion of the floor below, like 3.
Of 3, okay.
They own the full 4th floor.
Right, and so no fire separation between 3 and 4 is required where they're
no
similar use or whatever.
Yeah.
Or below.
Are all the condos in the building business occupancy?
Yes.
Okay.
Now, do they have a sprinkler system like an R, 13R in there?
Not
Condos.
Yeah, not the some where we've been told is a portion of the ground floor. There's some on 2, and we believe a portion of 5th floor is sprinklered.
Now, where you're gonna do this mock-up of like a hospital, right? Is that what you're doing?
Well, there's just like small exam rooms where they probably have like a dummy in there, and then they,
You don't have no medical gases in any of them rooms, do you?
No. There's no actual physical laboratories. This is mainly strictly only training. Like,
Basically, we should, yes, we can hear you. We should just pause.
Okay.
Just pause a moment so Josh can be sworn in.
So Josh, they need to swear you in first.
Yep. Josh, you there?
Yes, I am, sir.
Okay, Josh, can you raise your right hand? Swear to tell the truth, whole truth, nothing but the truth?
Yes, sir.
You're good. Okay, let's go. All right, go ahead. I think, Ted, you were asking a question or somebody?
I was going to ask Ryan, in a condominium situation, when there's a requirement that, say, the whole building be sprinklered, which includes properties that are not your own, is that, is it still, is the whole building, or it's not just the condominium? Just wanted to make sure.
That I don't know off the top of my head.
That might be a Matthew question.
Yes. So there is some language in the existing building code where it talks about your scope of work and not requiring work outside your scope area for supplemental sprinklers. Any work area, that exceeds, which we're a full floor, so we exceed that. But then, work area exceeding 50%, exception occupied tenant spaces and entirely outside of work area. So that's within the existing building code.
Which is this an existing building?
Yeah. So this is an existing building. So obviously, the sprinkler requirement is in the new work, but that's kind of, automatic sprinkler requirement saying, outside of scope area.
Right. So the quoted section from the refusal, hi, this is Matt talking.
711.
No, it's 1011.2.1. It's for change of occupancy.
Okay.
which says go to chapter 9 of the IBC. And then it says such system shall be provided throughout the area where the change of occupancy occurs. And then in the IBC, it just says the group A3 fire area has to be sprinklered from there to the level of a exit discharge. And so I guess what you're saying here is that you're only going to be able to sprinkler what your tenant owns, essentially.
Correct.
Yeah. So it will be provided throughout the 4th story, and the portion at the 3rd story that the tenant owns is already sprinklered.
No.
Okay, so just the 4th story.
So
Because
wait a
I've
second.
seen old COs and they all have very mixed information about what's sprinklered and what's not. So
Right.
I couldn't even really figure it out for sure what's sprinklered, what isn't.
But are any of the areas here that we're looking at in this, are any of these sprinklered on this floor?
No.
No.
None of the Intel's current owned space is sprinklered.
This is 5 stories, right?
Correct.
Okay, and is there a system in there, a sprinkler system?
So there's standpipes in one of the stand towers.
Okay, over 30 feet. Go ahead.
That because we talked to our Ballo's our engineer, sprinkler, and we said, you know, do we have enough? Because there's not a fire pump room in the building, but he said the standpipe and the fact there is partially sprinkling of the 5th floor, he says there should be adequate pressure to meet the requirements of sprinkler 4. So we did a preliminary plan review with this, and you know, back and forth. Oh, it's not required, it is required, and like they said, oh yeah, you could just get by with just doing 4. And I'm like, nah, that didn't make me feel comfortable because the code states fully sprinklered building, right? And
yeah, we want to confirm with the board, just, you know, to be sure. Because it's important to us and to the client, obviously.
Yeah.
For their staff, so
you're proposing to sprinkler whatever we confirm is required to be sprinklered.
That's correct, yeah, which would be the entire 4th floor.
Okay.
yeah, so that's this entire 4th floor.
Okay.
So nothing else in that building sprinkler except the 4th floor?
No.
The other way around.
Yeah.
Okay, everything in the building sprinkled except the 4th floor.
Not everything. So to our knowledge, again, we don't have access to the other floors, but what we heard, they have a building manager that told us part of the 5th floor is sprinkler, part of the 1st floor is sprinkler. So, but like I said, because we know our client, the floors that our client owns, the 4th floor and the part of the 3rd floor is not sprinkler, we knew that the building cannot be classified as fully sprinklers because of that. You know, so it's partially sprinkler. So, but it's not fully sprinkler. Yeah.
And
if you have a 5-story building, it would have to be a 13 system, which is a sprinkler that's upgraded. So was there any demolition on the floors that you took over, or did the sprinkler system get taken out?
No,
No.
it was never sprinkler. Yeah, because it didn't need to be, I guess, because it was a B use.
For B use, it's not required.
Right.
And are you doing any fit out on the part of the 3rd floor?
No.
And Matt, is the 3rd floor sort of excluded because it's a different fire area?
Yes, I believe the 3rd floor was completely excluded from the plans, and there's nothing indicating that they're doing any work to it.
No, yeah, we're not.
So basically this comes into play for the 4th floor in its entirety.
Yes.
And so you feel that is being interpreted correctly. There's no exception to that.
To what specifically?
To the requirement, I'm kind of wondering, the discussion of the kind of separate, or the, desire to have these 4 lecture rooms or whatever they are,
Classrooms, yeah.
combined. Is that what's triggering it, or is it just the fact that it's being fitted out?
It's because so because the classrooms are going to have those like movable partitions between them, it goes from just being individual like spaces with less than 50 people to being treated as one big one that becomes A3 as a result.
Right.
Okay.
And then the fire area, and then the group A3 fire area ends up extending to the whole of the 4th floor, even though it's split between B and A3.
Right.
And then just the one other question, when you're talking about the separation between the 4th and 5th floors as not being verified, if it turned out that were a 2-hour assembly, would that change the sprinkler requirement?
No, I don't believe so. No.
Okay, so
inherently
sprinkler is there regardless. I mean,
inherently it's a metal deck with 3.5 inches of topping poured concrete. Typically that is a 2-hour assembly, but we're basing it upon the building is classified as type 2A, and by a 2A type construction, that's only a 1-hour floor.
It's required
a 1-hour floor.
Right.
But it may be 2, but I can't tell. We don't have any existing drawings to confirm it.
And so the only reason I'm asking it, that wouldn't relieve you of the requirement.
No.
Yeah, okay.
No.
Just unclear.
So,
Question,
Matthew, this is existing building?
Oh yeah, it's old.
It's old? Okay.
Yeah, there's I did find old certificates of occupancy from like 1985. So it's been around a while.
is there any
And like,
advantage?
I believe. Amy, a question.
Is there any advantage to giving a lawful occupancy for this floor to kind of, in theory, spread out the assembly?
what's that again?
Have a lawful occupancy issued for this floor so that, I don't know, maybe it still meets the business requirement when spread out over the floor.
Right. So as in make it like, and instead of having one long string of classrooms with the movable partitions, it would just be all over the floor.
Kind of, yeah.
Just kind of so that no single room
Exactly.
would have more than 50 people in it at a time. Yeah, I mean, if you just have a bunch of rooms that are all that have like less than 50 people each, or it's like that and like less than 750. I think it's like that or less than 750 square feet.
Yeah.
Then like at that point, like the code says call it B.
Yeah.
Right.
But functionally, right here, you've got 24, seats in each of these 4. I mean, you want to have whatever 100 people be able to gather at one time. I mean, otherwise we wouldn't be having this conversation.
Right.
Correct. Yeah. They like I say, majority of the time it's going to be individual classrooms with a presenter at the front. But yeah, in the case they want to have a larger class seminar, they would open up these walls for that one meeting.
Would opening up that conference room to the right create a larger space and potentially, again, alleviate this problem if the conference room was not used while this presentation happened?
Well, this room here,
That's a boardroom.
it's a boardroom.
Yeah, they didn't want to connect it.
Yeah, there's a wall here with TVs for presentations and stuff.
Yeah, it's really just limited to these 4 classrooms.
Yeah, it's mainly this.
Yeah.
I'm just trying to help.
Sure.
I know. Thank you.
Yeah, and like we have, doors for each one, and because you're less than 49 occupants in each one, but combined, and like say our travel distances, etc. We're meeting the 250 maximum and everything.
So if this were set up as one big room, are you going to end up with more people than you would if it's set up the way it's drawn here?
Potentially,
but you still would need aisles, so you
Right.
might add maybe one row of desks, but you're still gonna need egress aisles
Yeah.
up here, so you might end 2, 4, 6,
It would
8.
be, it would be incremental.
Yeah,
it would be
it'd be
exactly.
minor.
Right, yeah.
And even so, this is showing like 30, is that 35 occupants is what it's sort of?
Yeah,
each-
there's 36, there's it's
Yeah.
roughly, 35-ish per room and,
Right, and they're drawn as 24, so.
yeah. And that's
So-
the max,
That's
basing
based on
on,
square foot. Yeah.
that divided by, 1 to
Yeah,
20
no, I-
classroom. Yep. So, it's actually less, what actual use would be less than noted.
Well, that's kind of what I'm getting at is, in a way, it's like making it all one big room doesn't inherently make it more, unsafe than.
Or my point is, you could have an entire building with rooms that are 749 square feet, the entire
Right, yeah.
place, pack it full, and you're still B.
Right. I think that's what Amy
So-
was getting at.
Yeah.
Yeah.
When she asked the
It's
question
just the
earlier.
fact that we just want to move these walls and have one seminar room.
Can you zoom out so we can see the full plan or
Sure.
the plan?
Yeah. So the rest of the space are just offices.
Yeah, so it's mainly, all office, existing core toilet rooms. We have additional toilet rooms we're adding to allow for additional occupant loading.
Any kitchens in there?
We have a pantry break area.
Okay.
No, not cooking.
No cooking, no, just,
Pantry.
a pantry.
Yeah. Just a sink and, refrigerators, yeah.
Yeah, and I'm not necessarily advocating when I say this, but just the reality is from this, large classroom or 4 classrooms, you come out into a hallway where you go left or you go right to a fire stair that's.
Yeah, we're literally right out, or, we have almost direct access.
John, what's your kind of reaction to this? Are you able to see it?
Yeah, I can see it. And I did drop off for some reason. I had to sign back on, so I apologize if I don't have all the information. That's okay. So is the appellant looking for a variance or an interpretation?
Well, do we need a variance, I guess, because.
Yeah, that's what I'm trying to figure out too. And
right.
to me,
Well,
to me, if it requires sprinklers, I think it should be sprinklered. I think room sizes, area sizes, and having just partition walls instead of fire rated walls, I do think that makes a difference for fire spread. I think different types of occupancies matter. So
Right.
I was catching a little bit what the L&I guy was saying, and I guess if it wasn't written in error, if it's an assembly occupancy with so many square feet and requires to be sprinklered, I think it should be sprinklered. And if you're asking for a variance, what would be the reason for the variance?
Because the code states fully sprinklered building.
And it's not fully sprinklered. So you're saying what?
For the entire building, right? But if we're saying each condo is a unit, then when we sprinkler our floor, then we meet the code
Yeah,
requirement.
I think, Matt, you were saying that if the entire 4th floor were sprinklered, it would meet the code, not really.
Okay. Let me just read. So who read the refusal notice? 'Cause I feel like almost no one did. Sorry. Like, no offense, but did anybody read it?
I read it.
Okay. Just checking. 'Cause I'm like, what are people talking about?
Yeah.
Okay, so the main reason why these sprinklers are required is change of occupancy to A3, and then
Right.
it says go to chapter 9 of the IBC, which then
Right.
says for A3, it has to be sprinklered if it meets one of the 3 conditions.
Right.
If the fire area is more than 12,000 square feet, if the occupant load is going to be 300 or more in that fire area, or if the fire area is located on a floor other than a level of exit discharge.
Correct.
So
Which it
it's really the third one,
Yeah.
more than the other 2 that triggers the sprinkler requirement, since it's A3 at the 4th story. And then the other refusal item has to do with heights and areas. because the IBC also requires that when you go from basically from B to A3 or B to any A, I think it is, it's a change to a higher hazard for heights and areas. So which then says just go to chapter 5 of the IBC and comply with that. So for a type 2A building that is non-sprinklered, which just means not fully sprinklered, it only allows you to go up to 3 stories for a group A3 occupancy. And so since you're at the 4th story, that's another refusal item.
So it wasn't written in error. It's on the 4th floor. The code, the way it's written and being interpreted, it should be sprinklered because it's an A3 occupancy on the 4th floor, correct?
Yeah. And it says it has to be sprinklered throughout all stories from the group A3 occupancy to and including the levels of exit discharge. So it has
Which
to be
they
from,
don't have control over all the floors, correct?
and that's the main, like, that's what it's saying. It's the main hardship is that they know the building is partially sprinklered, but like they can't force everyone from the 4th floor on down to like install sprinklers because they don't own all of it.
Okay, but
is what they're saying.
Is any of the floors below the 4th floor sprinkler?
Mixed information on that one.
What do you mean mixed information?
Old COs give different answers to all.
Well, isn't there if they have a sprinkler system, they get inspected every year? Every year.
I don't know how to find that information. So I believe they said that like part of the 3rd story that they own has sprinklers. I think the basement has sprinklers.
Right.
Some of the 1st floor does. Other than that, I don't know.
So the basements has sprinklers, the 1st floor has sprinklers partially. The 3rd floor has sprinklers.
Partially.
No, partially.
Yeah,
Okay.
Not the half of the floor that our client owns. Yeah.
Oh, okay.
Right. But
Got
the
it.
5th floor we were told was partly sprinkler. Again, like,
Right.
you know, again, if you stand in court, that's hearsay, right? Potentially. But we heard it from the building manager that they said the 5th floor is partially sprinkled. Yeah.
But can I ask you a question? Are you not really responsible for the other floors? So don't we got to deal with the matter at hand? Well, regardless what the other ones are doing, though, you can't fully comply because you don't have control. Does that negate the responsibility for sprinklering the 4th floor?
Does it negate our responsibility to sprinkle the 4th floor, you say?
Yes.
Yeah.
We're no matter what of the other floors that you don't have control. Yeah.
We're proposing to sprinkler the 4th floor.
Right.
We are proposing to sprinkler what we're looking to fit out.
Right.
Sorry, this is my name is Josh. I'm the Chief Financial Officer for InThealth. We're proposing to sprinkler what we are proposing to do the renovation for. It's what was just said. We cannot force other owners to sprinkler their units.
And this refusal was given to the building, not to the specific floor?
No, it's to us specifically. Right.
Yeah.
Okay.
But
all right.
And you own part of the 3rd floor, but you're not fitting that out, or yeah, okay. So it's only 4th floor. So is there calculated capacity that to sprinkler this floor? Is the fire service adequate?
You might need a fire pump. How about if they need a fire pump? Then it's for everybody because the capacity of that building. If they're
That's what I'm wondering is whether you know.
I don't know.
I have a question from Matthew.
Yeah.
Based on what he was saying, if this assembly space was moved down to the 3rd floor, would the sprinkler requirement go away? Because you said it's for above, up to 3 floors, it's okay.
Okay, so it's 2 separate items. So the sprinkler like requirement in of itself would not go away because because it's on a floor that is not a level of exit discharge. Like that alone makes the sprinklers required. The other thing about the like a 4 stories thing, that just has to do with chapter 5 of the IBC because of the change of occupancy classification.
Okay.
It's just a consequence of like changing the occupancy classification. It requires compliance with chapter 5 of the IBC for height scenarios.
Okay.
So it's kind of like it's still important, but like it's just like a consequence of the work. It's like it's just something that like I noticed. I'm like, well, I might as well put it on here because like it's technically something that they're not complying with. And I don't know what like variance you could grant for that.
Okay.
But like, yeah, if they move the group A3 to the third story, that item would just go away. But the sprinklers would still be needed.
And you.
The
in your-
sprinkler for the whole,
No, just for the fourth floor, right?
no, I'm just saying if the assembly was moved down to the third floor,
They'd
would
still
the
need it.
sprinklers for the
You
whole
would need
building
it on
be
the
there?
third.
Yeah, but then it would just be for the third story on down. And right now is technically it should be required for the fourth story on down.
Okay.
Which, you know, regardless of this variance or not, we were planning the sprinklering that floor, as Josh was saying.
Your appeal also says planning to create the 2-hour separation to the fifth floor. Is that, okay. Which
Yeah, that
may be needed or it may not be, but if it's not already 2 hour, you're gonna make it 2 hour.
Yeah, but you know, that goes back to like not having any existing drawings of the building, any design drawings. You know, just strictly looking at a type 2A construction, what's the required rating of that structure, right? It says 1 hour for primary floor, stuff like that. So that's what I'm basing it on, you know. We have to investigate that, but you know, supporting structure is another line item. You know, supporting structure, you know, we can't go into other floors and verify column ratings. You know, this, how much spray on do they have or not?
So given what they're proposing to do, Matt, I mean, would we have to give a variance to not require areas that they don't control on lower floors to be sprinklered?
Yeah, that's basically what the ask is. Is that the requirement would be fourth story on down sprinklers throughout. But they can't do the on down part.
Right.
They can only do the fourth story.
Got it.
Yeah, because as we were, advising our client that, you know, I know life safety is important to them. That's why they proposed to sprinkler, you know, the space that they work in. Just.
Did you guys have a sprinkler contractor look at what you're doing and do calculations that you wouldn't need a fire pump, or would you need a fire pump, or?
Not calculation yet, but they did look at the cost. They have a cost provided to the project manager. But they have priced it out that, you know, that the floor could be sprinkler.
We also have an MEP engineer on board. An engineer told us as well, if they have a standpipe feeding the fifth floor, there's adequate pressure to fully sprinkler this fourth floor.
They can tie into,
How many stairs is in that building?
3.
3 stair towers.
1, 2, 3. You know, separation, you have ultimate separation each end of the building and one centrally located.
So the third floor, you're just simply moving into as is, or are any renovations anticipated there?
Oh, no, they're already in the building. They own the floor and a half, And because of kind of, as most people with the kind of work from home protocol, they don't need all that space, so they can consolidate everybody on the fourth floor.
Well, what I'm getting at is, would it be disruptive to sprinkler the portion of the third floor that you do own while you're going ahead and doing the fourth floor? I mean, if we're saying, yeah, you don't have access, you don't have control over the third floor that you don't own, the second floor, that's one thing, but you do own part of the third floor.
Yeah.
What's the reason to not sprinkler that when you sprinkler the fourth floor?
Oh, because we're not doing any construction down there.
Right, but could sprinklers still be installed?
Installed.
I don't know what the use is or what it looks like on the third floor, so.
Yeah, it's all office.
It's office also.
Yeah.
Yeah, it's just office.
It's unoccupied at the present time, and has been unoccupied.
Okay.
Did you find out why they only did partial portions of the buildings to be sprinklered? Is there any reason for that?
I think our educated guess is it's for the very same reason that we're going through now, because they only own part of that condo. So that's why they only sprinkler what's required for their condo.
And per the building code, B use as it was built, you can build 5 stories, non-sprinklered, and the floor plate size, so it was not a requirement.
Okay. Amy, you want to caucus?
Yeah, I guess we should. Any last questions for Matt or John, or?
John, you have anything for us? Matt?
There are old COs that the oldest one is from 1972 and it says only the basement is being sprinklered. And they all very consistently say that until one randomly just says like entire building sprinklered, but like I just didn't think that was true. Because that just didn't really make sense, because the one like right after it also says basement. So yeah, so that's why I said on the refusal that that it was like partial sprinklered mixed information, because like I just could not confirm it for sure.
And that's the struggle we have, that's why we want to make sure we advise our client correctly. And that's why we want to appeal to the board, because, as Ash was saying, by definition, if a building is fully sprinkler, every floor has to be sprinkler, but the floor and a half that we own is not. So that's why we're proposing, sprinkler the floor that we're doing work in.
All right.
Let's caucus.
Okay. Oh, there he is.
Okay. What we're looking at is you're going to sprinkle the 4th floor. On that 4th floor, we'd like to see it in all those rooms, no more than 100 people. Between the 4th and 5th floor, check and make sure they have the 2-hour fire rating or separation. The thing is, and our dilemma is that we can't tell other people in that building to put a sprinkler system in. I don't know how we do that. So the best thing we can do is have you sprinkle the 4th floor. I mean, the 4th floor, and put the fire separation in there and keep 100 people in the pods that you have.
Yeah.
Okay.
It will be
so it'll be a posted use. Okay.
Yeah.
And our reasoning is that's about how many people you have in 4 individual classrooms. We're just saying, let's keep it about that for the assembly.
Yeah, that was kind of our reasoning all along.
And if things change, with the sprinkler system that you have to put a pump in, I don't know if you would, but if it changes, it's still going to stay the same.
Right.
Okay.
Yeah.
All right, guys. Good luck.
Thank you.
Thank you.
Thank you very much.
Josh. Okay. Bye-bye.
Yeah.
Okay.